Hello and welcome to Acclime's podcast series, Advancing Vietnam, with me, Vlad Savin, as your host. In this episode, I'm discussing with Matthew Lourey, Managing Partner at Acclime Vietnam, about the 5 most important steps investors should consider when registering a foreign-owned enterprise in Vietnam the right way. Matthew, welcome again to our Advancing Vietnam podcast series. This is back to basics topic, but the narrative and the spin that we're looking to focus here is really on those important insights, not just about the process, but the overall risks and responsibilities of investors when they're looking at setting up.
Great to be here, and I look forward to discussing the topic.
Establishing a company in Vietnam is a significant step for foreign investors and hopefully the beginning of a successful endeavor. Anyone that went through the documentation have seen either C application, the investment registration certificate. They understand the frustrations and the substantial paperwork required in Vietnam just to commence the process. To simplify this and to enable our audience to have a clear view on the processes, principles, and governance framework of an enterprise, I will condense all the incorporation provisions in 5 key steps which investors should seek to cover when setting up their enterprise in Vietnam. So Matthew, let's start the discussion first with probably the most important step in the market entry endeavor, identifying potential conditions, restrictions for investors, and assigning correct business lines aligned with the future company, ensuring that they meet the goals and strategy of the company.
And before addressing that, just to put a foundation on this whole topic and this particular question, is that Vietnam is a process rules-based system. It is not based on logic. It's not based on principles. Therefore, everything it is, what is the rule? What is the process? It's identifying what that is and following it. And in this case, one of the first steps that you'll put forward there is what is the company permitted to do? Unlike common law companies, which generally can undertake any activities they want unless there's a restriction, Vietnam's the converse. You can only undertake activities for which you hold appropriate license. For example, I have a coffee cup in front of me. Our business cannot sell a coffee cup because we don't have a license, a retail license or an F&B license, etc. It's very specific what you can do. So in that case, identifying what they are, whether it is a professional service, whether it is a very defined area of law, whether it's general, and that takes a bit of effort to go through and understand what those activities are. Some are restricted for foreign investors. Some have sub-license requirements. Some of those sub-license requirements might require a certain number of people with certain certifications. It might require premises. It might require a range of activities. But understanding what are the specific business lines that you wish, the restrictions attaching to those, and any sub-license or other requirements attaching to them, and building a picture of what it is. If you're wanting to do certain activities, it can be very simple. Some can be very complicated, and some can be location dependent, some can be staff dependent. So it does take a bit of while to understand that. But that first step of identifying and working out those business lines, what you want to do and what lines are relevant. Just on that, we see people come in, put everything down. It doesn't work like that. You can put a lot more down. Expectations of the authorities have a much higher capital. And you end up with much higher, greater scrutiny and inspection. You're better off putting just what you need and then adding later if you wish to expand than you are to just go bang and put everything down. It's going to slow the process, and it's also at risk that you're going to fall foul of both capital requirements or the authorities not wanting you to just scattergun and pretend you can do everything.
Mm-hmm. The second recommended step is to ensure investors have a clear understanding of the required documentation for the setup, which takes into consideration documents reflecting the nature of the investor, in some cases the nationality or location, which can impact as well the timeline for a setup. Can you go through on the documentation side and as well on the investment requirements, potentially on nationality and location?
So your documents must be your foreign documents of a foreign investor, and we'll talk about foreign investors. The local investors is far simpler. A foreign document will not be accepted in Vietnam unless it's been consulised, legalised through the foreign government and then the Vietnamese government. So generally that requires Department of State or a court and then Vietnamese embassy. So all documents need to be legalised, consulised for use in Vietnam so that they are accepted as a Vietnamese document. Otherwise, foreign documents aren't accepted. And that's the biggest frustration. That's the biggest concern matter of doing a company or rep office or anything in Vietnam. That is the concern. So understanding that a document is not legal until it has been stamped is that potentially biggest time delay. And some countries that can take a long time, some countries it's very fast. So what you will need is evidence of the identity of the investor, an individual, passport. If it is a corporate, you will need to make sure that you've got certificate of incorporation, potentially a company charter, potentially the most recent confirmation of standing with the foreign authorities at the company's regulator is effective, passport of the representative, the chairman or the director representing that company. Those sort of documents which show capacity and show who it is, they need to be legalized for use in Vietnam as part of that document process. So getting those documents. Now, nationality is not only an issue on timing. Nationality is interesting, whereby, for example, retail and commercial activities in Vietnam, only WTO members are permitted. So if you're not a WTO member, such as Vietnam, often the past British Virgin Islands is used, and the Cayman Islands, as they flow through simple jurisdiction, they are not WTO members. Therefore, if they are the investor, they will not be permitted to invest in activities that have commercial retail type activities. So there are restrictions. So it's not just, it is jurisdiction focused to make sure that the commercial activities are being done in the spirit of what Vietnam wants, but also that the documentation is appropriate. So it is that exercise of getting that right. Again, we see people sort of, do I have to do this? Can I do something else? Don't fight the system. Don't logic. Don't try to look, rationale and reasoning. They're the documents. That's the process. Follow, prepare, just bite the bullet and get those prepared.
And speaking of the process, we're coming up now to the third stage of the preparation for investors in Vietnam, really understanding and undertaking the process and the timeline efficiently and effectively in Vietnam. Can you share what are the stages for the actual setup and what is the projected timeline so investors have that understanding and don't set wrong expectations in expecting in a couple of weeks everything to be ready instead of a couple of months, for instance?
So we normally say it's 6 weeks in country. So that might be 2 weeks, might be 4 weeks out of country getting documents. As I said, step 2, step 3, we say it's 6 weeks. It's actually less than that. We've seen 2.5 weeks. The law says 15 days for this IRC, the Foreign Investment Approval, and it says 3 days for the ERC, the Enterprise Registration Certificate. Now, add a day either side of those because of lodgement day and collection day. We commonly see errors, administrative errors, spelling, etc., particularly foreign words. So it's not uncommon to collect a certificate of incorporation, the ERC, and have to relodge for amendment and take a few more days to collect. Now, you've got a few days in between. If you've got your application forms, your supporting documents that have all been translated, so you've got your original documents, you've translated them, you've filled in the application forms, everything's signed in blue ink by the investor and the appropriate representatives, everything's been done, you've got your documents, you lodge it, you can do it in theory in 2.5 weeks. That's in theory. It's rare, but in theory. If in practice, depending on which province, 5 weeks is generally comfortable if you have those documents. So the advice is come prepared, follow the process. Don't get all the documents in country and, what I need, have to get the investor to sign a new application document, or I missed this form that's required for the IRC. It really is, as an advisor, plan to get your company documents, step 2, and step 3, get all the application documents signed, the appropriate appointments of power of attorneys, the appropriate everything, so that the individual lodging, and remember, the individual lodging those with the authorities must have the power to lodge. So there's things such as appointment of power of attorney for lodgement. You get all those documents ready so that it is simply a filing exercise. They're filed digitally and they're filed manually, and they both need to be done in that process, blue ink. And so there is some queries abroad. If the investor is not in Vietnam, plan ahead accordingly. So time frame, it's not as long as some people perceive. One thing is that if the application has restricted sector, back to step 1, if there's additional requirements, that timeline gets blown out. If it requires ministerial approval, forget it. That timeline doesn't exist. So we're talking about unrestricted, simple businesses and not those which have additional requirements.
And where there are restrictions or conditions, the timeline can be 3 months, 6 months, 8 months, 9 months. So it's
longer.
It
Unknown.
really depends. Yes.
Unknown. And where it involves a ministry, it's effectively up to the ministry to deal with it. Where it's not, where there's a sub-license, where there's a certain thing, there may be a timeline, but it depends. It's very broad.
The fourth stage is ensuring the company has a relevant legal representative assigned that meets the statutory requirements for taking on these positions. Investors should have a deep understanding of the responsibilities of the legal representative in Vietnam and seek to appoint individuals that are capable and are liable to undertake this position and as well have those responsibilities attached to this function. What can you share about the legal representative?
So we don't have the same concept of directors that a common law country has. So in Vietnam, the legal representative is that party with capacity for the enterprise. And an enterprise, an LLC in Vietnam, doesn't have individual capacity. The individual capacity is through the legal representative. And we could compare that to a director in a common law country. So the legal representative is responsible, has power, and is liable because it doesn't have capacity. If there's any lawsuits or authorities or anything else, it is through the legal representative. They are held responsible. And just as an aside, when you see a Vietnamese contract, you will see the company name represented by who has the capacity to deal with and sign. Everything has an individual with capacity. So that legal representative, you can have multiple legal representatives. One of them needs to generally reside in Vietnam. They have a Vietnamese address. And if they're out of country more than 30 days, someone else must be in country or someone else appointed. So there's a 30-day window to make sure that there is someone in country. Commonly, you'll have a legal rep outside country, one inside country. You can have multiple there, but quite commonly one outside, one inside. And we always recommend two, so that if someone's incapacitated for whatever reason or on leave or something, there is always someone with capacity, organisation. And just as an aside, we two stamps, each of them should have their own stamp. And so we just want that, so there's continuity and removal of risk. So the legal representative is liable, but indemnified out of the assets. They have responsibility. And the law, for example, just to give you one example, the Tax Administration Act law says that if there's tax liabilities that are unpaid and the demands have been sent by the tax authorities, they can prohibit the legal representative from leaving Vietnam until they've settled those debts on behalf of the company. So there is responsibilities that exist, and the legal rep is the most critical position. So just on a company structure, legal rep runs the company's full capacity. They can appoint what's called a general director or a director, which is like a general manager. They have operational, and they can be the same. Legal rep can be a general director. There's also the chairman role. We often see that, or chairman of the members' council, which is above the company. So the chairman appoints, or the members' council through the chairman appoints the legal rep, terminates the legal rep. So because that's the top inside, there's someone overseeing them, which represents the investor, the foreign company, which is the chairman or members' council, and they are appointing and removing that legal rep.
How easy is to terminate the legal representative?
Quite straightforward, actually. Forget the labour law issues. So if there's labour contracts and labour law issues, that's a different matter. And you've got to be careful and cognizant of how that works together. But let's ignore that and just deal with purely the corporate side of things, enterprise law. You can remove the legal rep very simply if there is a new person to replace them, or if there's two legal reps, you can just submit and remove the initial legal rep. It does not take effect until it's processed with the authorities, but there's no clearances, there's no approvals, it's just a submission process. But there must be one. So if you have one legal rep, you must have someone to replace them, otherwise you can't remove them. So a relatively benign and simple process. It doesn't generally need the consent of the person being removed, but there must be a valid removal, and it must follow the charter and must follow the enterprise law.
All right. And let's look now at the last stage for investors when they're looking at setting up in Vietnam and trying to understand the specifics of the structure and how it works. Funds flow. We talk quite a lot with investors looking at capital requirements, but as well, the majority of them, they're not really aware of how dividends look like, or how loans, or when do they have to register, how does it all work. So having this broad and very specific understanding as well on funds flow, I think it's essential for investors from the outset when they're setting up a company to ensure that the structure meets their goals and specific needs for funds flow.
Yeah, I start the conversation, people go, how much money, what's the minimum capital, what has to come in? I start the conversation with, how much money do you need? What is your money that you need to run that business? What's your float? What is it going to cost you? Because that's what the authority is going to want to see. Forget how you measure it, forget how you determine that. That's the commercial answer. Now, putting that aside, for a very simple service business We generally recommend $20,000 as the charter capital. I'll explain what that means. 20,000 is not in law. You can do less, you can do more. There's reasons why, there's safety and there's experience, and I think other parties in a similar thing use a similar number. That's not a legal requirement. There's just expectations of the authorities, and to come back to the authorities are looking at this in a commercial sense. That is also the number to justify why they will approve a foreign investor to enter Vietnam. What are they going to bring to the country? Are they going to bring sufficient capital to make it worthwhile to Vietnam to approve that investment? It's not the foreign investors not doing any favors for Vietnam just because they're nice. There's a commercial element, and Vietnam needs their stake out of that. So that's the charter capital. Charter capital is akin to share capital. There's a second part of it, which is your total investment capital, which is effectively loans. So you can have $100,000 investment capital, $20,000 charter capital, $80,000 loan capital. Just an asterisk, there's draft laws which may change this, but let's talk about how it is at the moment. So you can you're required to bring in that charter capital, the 20,000 or whatever that number is, within 90 days. There's no way around that if you don't do it. And we've seen issues in recent times again where people miss the deadline. It's a significant problem. So you must bring that in. That loan capital can be brought in when you need it. And there are, depending if it's short-term or long-term purpose, there's registration or non-registration, but it's relatively easy to bring in loans. In fact, more than that can be brought in for short-term purposes. If there's, you follow the process, you're not restricted to that amount, by the way. You can bring in further short-term, but that as a long-term point of view, it's within that ratio. And you need to prove you've got capacity when you apply that we can fund it. So you've got to show evidence that we can fund that, and that will bring in our minimal charter capital, and we can have additional loan capital. That's all going to go through a very specific bank account that you set up called a direct investment capital account. All your loans go through there, your charter capital goes through there, and the banks will police this very strictly. There's no way around to try to do anything else. And then if you want to repay a loan, if you decrease your capital, maybe you've got a larger capital and you decrease it, your money goes back through that bank account. It allows you to bring it in to send it out. That is the sort of the border control by the state bank, and that's how that interacts with the enterprise law. And a dividend, you can declare a dividend once per year. You declare a dividend, you notify the tax authorities, you notify your bank, you wait 7 days. If there's no objection, i.e. you are currently compliant with tax laws, the authorities will let you remit, will not object to you remitting that out. And if there's no objection, you remit that out of that capital account. So what happens in practice is that people don't generally keep money in that capital account. It's not really a float, could be, but they will take their current account. Upon a valid reason to sending out, their bank will transfer from current, either VND or USD, whatever it is, to the capital account, whatever currency that is, and then send abroad. So it works, and it's not a complicated process. It's not a lot of documentation. It just needs to be valid. So generally, if you're ready for it, you send your docs in, it goes out same day. Mm-hmm. As in a valid request, provide your documents are in order. It's just a process to go through.
Mm-hmm. And why wouldn't the investors try to acquire a company here in Vietnam? Just buy a existing company that has already the bank account set up, has already a charter, has already the business lines. Why would they go through this entire process? Isn't there an easy way?
It's a good question. I'm trying to answer that in a positive way. There are transactions occur all the time. If you've got an active business with business and assets and staff and businesses, sure. Do your due diligence, make sure you're aware, make sure you've got indemnities, etc. Active business with appropriate business lines, particularly those business lines which are hard and complicated, as we said, the steps at the start. If they're difficult, that might be the easiest process. What I would say is never buy a shell company. And I was dealing with someone the other day and they said, I bought this, it was a shell company, it was empty. It had a previous life, it was trading, it was activities in a previous life. So now, under tax inspection, they have some documents, but they can't justify what happened in a previous life. So the tax authorities are going to hold them to account for everything that occurred with the previous owner, and including the documents that no longer exist. So the current owners are going to be penalised, and there's no way to indemnify. There's no way to remove against that. There are mechanisms to decrease it, but that liability of past acts that you effectively can never remove. They exist forever. So it is very uncommon. very, very uncommon to buy a shelf company, an empty company. It is common to buy an active business with appropriate business protections, due diligence, spending the money to protect and get the documentation and retentions. It is not something you do for an existing company. Existing company that doesn't have any activities. You're buying it as a shell. It is cheaper. And just sorry to digress, it is cheaper in the long run to set up a new company than it is to buy an existing company, get the M&A and transaction approvals, do the whole process, change everything else and look after and then defend what's happened in the past. It is significantly cheaper to do the new company in practice.
And it's really not about being easy or hard. It's really about having a clear strategy and a clear goal with the company that you're looking to acquire.
And sometimes it appears to be faster, buy something that already exists. It may be faster on the surface, but that risk and that time and time again, the risks and the problems, historical problems, particularly if been around for a while, you can't remove that. What if that company didn't file their initial registrations properly and you've got this latent penalty building up and they do not permit you to do export because you've got a historical penalty and you're deemed in the blacklist of a non-compliant company and you can't export your goods that you've decided to make through that company. There are ramifications that are significant, so we really would discourage that as a process.
Matthew, as a final question to kind of close up the discussion, where do you see investors coming in the market? Where do you see for them the biggest gaps and the biggest mistakes more often made by them in the process of setting up in Vietnam? And what would be your advice to them when looking at registering an enterprise?
In that context, the biggest mistake I see, the biggest thing is trying to save a few cents, save a few dollars and cut corners at the start. We see that time and time again, where someone relies on one person. I've got a friend that can do it cheaply. As soon as I hear that, I've got a friend and I've got someone who's doing it cheaply, it's just going to lead to trouble. The issues we see of incorrect capital declarations, they can never fund it, then the company's stuck and has to be dissolved. The tax liabilities, the inherent liabilities, the fact that the business lines aren't appropriate or documents weren't filed constantly. So just do it right, understand the process, get advice, understand the process, follow it through, get education, spend time with the professionals to understand, and don't do it as part of a cost saving exercise, because it will cost you significantly more in the long run. It will never save you money.
Thank you, Matthew. Our time is up. Thank you for participating again in this podcast episode.
Great to be here again. Thank you so much.
When establishing a business presence in Vietnam, the parent company or founder should have a clear strategy in mind from a business perspective of investments, ownership, and potential exit options, even if the strategy is not one based around an exit. The 5 stages for registering a foreign enterprise company in Vietnam reflect critical investment decisions in the market entry strategy, and depending on how these initial processes are undertaken, they can have a major impact on the business growth, profitability, and future sale of the company. And many thanks to you, our listeners, for tuning in to Advancing Vietnam podcast series. For more information about this topic, please check out our publications on vietnam.acclime.com. And if you want to reach out to us for any additional details, feel free to contact me on LinkedIn or throughout the website contact details.